Good morning, everyone. I'm Rose Corrigan from Klein School of Law, and I'm really honored to introduce the first panel of today's symposium, Examining Abortion Access and Care. Personally, as I've been watching the developments out of Louisiana and Mississippi and Texas over the last few years, I'll admit that I'm feeling some deja vu. In 1992, many of us thought that a clear conservative majority on the Supreme Court would use Planned Parenthood versus Casey to strike down Roe v. Wade. And as some of our panelists this morning will discuss, we are facing a similar threat now. But at the same time, abortion care in the US today exists in a markedly different world than that of 1992. We've seen political and technological changes that have reshaped the landscape around abortion. And the COVID-19 pandemic has absolutely highlighted ongoing challenges to ensuring that all individuals seeking abortion services have access to safe, competent providers. But US responses to the pandemic have also created opportunities to explore new models for delivering abortion care. So our panelists this morning are going to cover an enormous amount of ground in charting how persistent legislative and legal challenges to abortion are intersecting with changes resulting from the pandemic. Now, just to note, they will be speaking in a different order than is listed in the program. So we'll begin with Christine Castro, then onto Maya Manian, Jennifer Groves, Rachel Rebekah, and we'll conclude with Farah Diaz-Tello. So I'll briefly introduce each panelist immediately before their remarks, and I encourage you to look at the expanded bios provided in the symposium materials. Just a note, if you have brief clarifying questions during any of the speakers' remarks, I invite you to submit those using the Q&A function. If time permits, I may be able to ask some of those of the panelists right on the spot, but I'll hold most questions until the end of the panel when we can invite everyone to join in the discussion. So our first speaker is Christine Castro. As a staff attorney at the Women's Law Project, she works on reproductive rights and health through advocacy, impact litigation, and policy change. She also provides direct legal representation to young people in judicial bypass proceedings, which is one of the topics she'll discuss today. So Christine, I'm delighted to turn it over to you. Thanks so much.
Thank you so much, Rose and Drexel Law Review for this invitation. It's a pleasure to be with everyone this morning. My name again is Christine Castro. I use she, her pronouns, and I'm a staff attorney at the Women's Law Project. I am going to be speaking specifically about young people's access to abortion in Pennsylvania during COVID-19. And I believe someone is going to be controlling my slides. Is that right? And are they visible to the audience right now?
I'll pull them up.
Okay. So I was a little ambitious with how much I wanted to cover. So I might zip through some slides just so that we really get to cover the main point of my time. So just for those of you who don't know the Women's Law Project, we were founded in 1974, and we're a nonprofit legal organization working to defend and advance the rights of women, girls, and LGBTQ people in the state of Pennsylvania. And we carry out our mission through policy advocacy, high impact litigation, education outreach, and also direct legal services. And one component of our work is providing legal assistance and representation to young people who are seeking abortion in Pennsylvania without parental involvement. So, Emily, could you go on to, and so just the image on this slide is thank you to our communications director, Tara Murtha, who has done a lot of work to ensure that young people have access to information about their legal rights when it comes to accessing abortion in Pennsylvania. So though our physical offices are currently closed, we are working remotely, and we are still available to speak to young people who are pregnant and seeking abortion without involving a parent. So the next slide, Emily. And this is just a roadmap of where I intend to take us. So just starting with a overview of abortion laws and regulations here in Pennsylvania, specifically our parental involvement law, and then some ongoing problems that we see with judicial bypass. And then specifically looking at how some of the common barriers that young people encounter in trying to access abortion without involving a parent, how many of those hardships were made worse during COVID, but then also to how there were opportunities that were presented during COVID to expand access to abortion care in certain parts of our state. And then in conclusion, some takeaways and short-term solutions. Emily, can we go on to the next slide, please? So this is just a quote to emphasize of how large Pennsylvania is and the fact that there is, we have 2 metro areas, the biggest one's Pittsburgh and Philly, and then everything in between is vastly rural communities. And on to the next slide. And due to a host of restrictive and medically unnecessary abortion regulations in the state of Pennsylvania, abortion is out of reach for many people in our state. We have, as of this year, 17 freestanding abortion providers that collectively provide over 90% of abortions that are performed in Pennsylvania. And only 18% of Pennsylvania counties have a facility where people can access abortion care. And so that means that many patients are traveling hundreds of miles to access abortion care in our state. And this is a map to just highlight where the clinics are physically located. As you can see, they're mostly concentrated in the southeastern part of our state. And then we have 2 freestanding providers out in Pittsburgh, and then in between it's an abortion desert. And what is important to highlight too is the fact that in southwestern Pennsylvania, we border Ohio and West Virginia. So these are states where access is becoming increasingly difficult to obtain. So we're seeing an influx of people coming from those states to access abortion in Pennsylvania. And so our parental involvement law, sorry, I'm just trying to catch my notes. So in Pennsylvania, one of the many abortion restrictions that we have is that young people, so people who are under 18, either have to obtain consent from one of their parents, or alternatively, they can ask a court for permission to consent on their own to their abortion care, and that is known as judicial bypass. And upon filing a petition, the judge has to rule within 3 business days. And by and large, most of our clients that we represent in bypass proceedings, we plead maturity. So that's one standard that the judge can evaluate whether or not to grant the petition. The other is if the judge determines that the petitioner is not mature enough to make this decision on their own, it has to consider whether the abortion is in their best interest. And one difference that we see in our parental consent law and from other states is that there is a choice of venue. So the petitioner can either appear before a judge in the county in which they live or in a county in which they are seeking their abortion care. And in most cases, you're going to have a minor petitioning the court in which they're seeking abortion care. And so in one of those 17 counties or 16 counties that were highlighted in the map. If the judge fails to rule within 3 business days, then it is treated as a constructive denial and the minor has an automatic right to appeal. The way that the statute is written, it requires that the appeal be treated expeditiously, and the appeals court has to rule within 5 days of the notice of appeal. So the next slide, please. So some of the logistical and legal barriers that minors encounter. We know that parental consent law here in Pennsylvania doesn't operate in a vacuum, right? So there are many other restrictions that minors are also needing to navigate, such as a forced 24-hour waiting period, a state mandated lecture. There's a funding ban as well. And what's important too to consider is the fact that young people have less control over their schedules, are more likely to not have reliable transportation, and less likely to have the money to be able to cover the cost of their abortion. So in order to obtain access to care, they have to jump through a variety of hoops. And one example to just share about the lack of control over the schedule and how this presents a problem, a unique problem for young people, is the fact that often at times these bypass hearings are scheduled during school hours. So a issue that a minor has to try to navigate is how can they miss school without alerting their parents. And many schools now have this system in place where if you're not present during homeroom, there's an automatic email sent to a parent or a phone call at the end of the day. So in Allegheny County, which I'll talk about in more detail soon, the Law Project worked with court staff to provide our clients with excuse notes so that they could present them at school and kind of avoid the automatic notification to their parents. And then also too, as I mentioned, a lot of our significant part of our representation includes minors who are traveling from West Virginia and Ohio. So the crossing state lines and all of the other things that they have to kind of navigate is even more profound for them at times. So the next slide, please. So these are just to highlight some of the ongoing problems that we see in bypass. They inherently cause delays. So even when you have the and when I say best bypass system, I mean when you have a system that operates with ongoing communications between the lawyers representing petitioners, the clinics that are providing the care, and the court staff that are facilitating bypass hearings, even when all of those folks are in communication and you are streamlining the process, it still causes delay. And that can never be good for anyone who's seeking time-sensitive care. And another problem is the fact of the shortage of abortion providers, so increasing travel distance for young people that need to obtain care. And then there's also a common issue that we see with lack of training among the advocates, the legal advocates who are representing petitioners. And then the next slide, please. And bypass inherently is a cruel and unjust system that can inflict trauma on young people, especially those with marginalized identities who are more likely to experience hardships navigating the court process, and also more likely to encounter gender and racial bias from judges and court personnel. Next slide. So I wanted to really focus on Allegheny County because that is where the Law Project's direct representation of bypass petitioners began in 2018. And again, I want to just emphasize that our position at the Law Project is that the best practice would be to not have bypass, and that young people would be able to make these decisions on their own without these state-imposed barriers. That being said, until we get this awful law off the books, we've been working to make sure that bypass is accessible for young people in Allegheny County. And so the next slide is just to highlight the fact that the Law Project has been working in partnership with the 2 clinics in Allegheny County, which includes our independent provider, Allegheny Reproductive Health Center, and Planned Parenthood of Western PA. And this is work that started in 2018, where we streamlined the process by working in partnership with the clinics and staff to minimize confusion and delay that minors encounter in trying to access bypass, and to also improve practices with respect to the representation of petitioners in bypass proceedings, to ensure that we're not adding harm to an already stressful, inherently disempowering experience, but rather how can we affirm and center the needs of these young people that are going through bypass. So the next slide. In March of 2020, our governor issued an emergency order closing all non-life sustaining businesses. Fortunately, Pennsylvania recognized that abortion care is life sustaining, and so our clinics were able to remain open. And then the next slide highlights the judicial emergency order. So on March 18th, the Pennsylvania Supreme Court issued an order closing state courthouses except for essential court functions. And it explicitly included certain what it deemed essential court functions. So that included emergency bail review, juvenile detention, and child custody proceedings. What it didn't explicitly include was judicial bypass. So with the order coming out and then county courts respectively issuing their own orders of how they were going to handle the closures, we saw that some orders did explicitly include bypass, others did not. So this kind of added already to more confusion and uncertainty to a system that, depending on what zip code you lived in, already was fragile. And the next slide is, even though the order didn't explicitly include bypass, there were legal arguments and reasons why it should be considered an emergency proceeding that's entitled to remain available, both constitutional reasons, both in federal and state, and then as well as statutory reasons. So our statute that governs parental consent and judicial bypass proceedings specifically states that these proceedings have to take precedence over all other pending matters. So if we encountered a problem, which we did not, there were legal, reasons and arguments that we could make that why courts had to keep these hearings available. And then the next slide is just also the practical reasons. Abortion is time-sensitive medical care, and any delay harms patients, and especially with minors who are also encountering that additional obstacle when they are not involving a parent and they need bypass. The lack of a prompt and expedient judicial bypass process can harm their well-being and health. So next slide is that during this time we saw that there was an urgent need for remote bypass hearings. This is something that we wanted before COVID, was to have these hearings made available remotely, but it wasn't as receptive we didn't have it in place yet. So, but then COVID presented this opportunity where it was required out of necessity. So court shifted to providing bypass hearings remotely, and specifically in Allegheny County, this is something that we started working on immediately, the Law Project with court staff and also the clinics, on how we are going to provide bypass hearings remotely. And that was necessary to ensure that we were complying with mitigation efforts for COVID-19, and also responding to the barriers and obstacles that minors were encountering during COVID. So all of the pre-existing obstacles were now compounded because of COVID with stay-at-home orders and school closures. Minors had even less privacy when they were in home with their parents, and less access to public transportation to actually get to the clinic. So it was completely urgent to really get this instituted. So the next slide is, this is what the silver lining was with COVID with respect to bypass, was that the accessibility of remote bypass hearings made it so that bypass became more accessible for young people who otherwise would not have been able to, because it removed the need of going to court in person. And even logistically, if you could get there, there was that inherent fear and stress of having to present at court and go through security and meet with the judge. And so the accessibility of remote bypass hearings during the pandemic also showed how significant these barriers had been. And so while ultimately we want to have a world where we don't have parental involvement laws, forced parental involvement laws here in Pennsylvania, the remote bypass hearings did create this change that made it more humane and accessible for young people. We are continuing to do remote bypass hearings in Allegheny County, and we represent folks from Ohio and West Virginia, as I mentioned. And what we saw within the year and a half of doing remote bypass hearings during COVID was that we had we saw the volume of bypass representation nearly triple. So again, there were many more young people that we were representing during this time. And the next slide is just a snapshot of some of the demographics, specifically the age of our clients. So during this period from March 2020 to June 2021, most of our clients were 17 and 16 and early in their pregnancy. We had, what was really significant was, again, the amount of travel distance. So anywhere from less than 40 miles to over 100 miles one way. And then the next slide is, I just wanted to briefly touch on a study but since I'm almost or over time, it's just and I want to thank our interns, Emily and Alex, who've been doing this study. So this study started in July 2021, and it's mirrored from a study that was done in 1999 by Helena Silverstein. And it was what our interns have been doing recently is calling county courthouses to see how prepared they are to handle bypass cases. So asking questions that minors would ask who are seeking to undergo bypass. And what we saw, which we were not surprised to see, was that an overwhelming majority of courts are not prepared to assist minors in pursuing bypass, answering basic questions, and just getting information to people to actually be able to know how to go about getting a judicial bypass in that respective county. And these are just some short-term solutions that we've identified based on the work that we've been doing. A lot of the problems that we see is the fact that it's county-based, and so there is a wide disparity on your experience of accessing bypass and what it looks like depending on where you're getting it. There's a need for recruiting more attorneys to represent bypass petitioners, especially younger attorneys with diverse backgrounds that can actually do the course of representation in a way that really is respectful and relatable to the young person that they're representing. And just in conclusion, when thinking about what abortion access looks like for young people in the future, the hope is that we don't have this forced parental consent provision in Pennsylvania, and that young people can make these decisions on their own without having to ask for permission. And that also that they continue to receive the information and support to make informed decisions about their reproductive health and sexual health.
Okay. Thank you so much for those remarks, Christine. We'll come back to you. I know I have a whole bunch of questions. I'm really interested in the project that you're working on. But right now we'll turn to Professor Maya Mannion, whose scholarship examines the intersections of constitutional law, family law, and health law, with a particular focus on access to reproductive health care. And her comments will explore this term's Supreme Court cases involving abortion rights. So Maya, let me hand it over to you.
Thank you so much, Rose, and thanks to the organizers for inviting me to this wonderful conference. I'm going to share my screen now. Hopefully this is going to work. All right, I think we're good. So I am going to be focusing primarily on two cases that are before or will soon be before the Supreme Court this term. The Supreme Court is poised to make some momentous changes to the law on abortion rights. Since the 1973 decision in Roe versus Wade, the Supreme Court has repeatedly reaffirmed that states cannot ban abortion prior to viability, which is typically around 24 weeks of pregnancy. However, in 2018, Mississippi passed this law banning abortion at 15 weeks with very limited exceptions. Federal courts did strike down the Mississippi abortion ban because they had 50 years of precedent stating that abortion prior to viability is constitutionally protected. After federal courts struck down Mississippi's ban, Mississippi asked the court to intervene in Dobbs versus Jackson Women's Health Organization. And that case has opened up a serious challenge to the right to abortion prior to viability. Then in 2021, Texas passed Senate Bill 8, making it effectively unlawful for physicians to provide abortion care if they detect electrical activity, cardiac activity in an embryo, which typically occurs at about 6 weeks. So the Supreme Court is scheduled to hear arguments in the Dobbs case on December 1st, and a decision is expected this term, and has been asked to hear arguments in the Texas SB 8 case as well. So I'm going to provide an overview of the legal issues and the potential impacts of the Mississippi and Texas cases. And then I also want to situate these legal issues in the framework of reproductive justice in discussing who is going to be most impacted by these abortion bans and by what the Supreme Court is poised to do this term. So in Dobbs, the Mississippi case, the Supreme Court has agreed to reconsider whether pre-viability prohibitions on abortion are unconstitutional. Now, the Supreme Court heard an emergency application in the Texas case, and it claimed to be stymied by procedural questions, which I'll talk about in a bit in the Texas case. But the Dobbs case really goes to the heart of substantive legal rules protecting abortion rights right now. So in both the Mississippi and Texas cases, we're faced with this question: where is this US Supreme Court going to draw the line on access to abortion care? There are a few different possibilities. One possibility is the court will strike down SB 8, the 6-week ban, but uphold the Mississippi law and allow states to ban abortion as early as 15 weeks. This approach would allow the court to claim that it is not outright overruling Roe versus Wade, it's merely tweaking the rules. But of course, the court would be reversing long-standing precedent that abortion cannot be banned prior to viability. So in Dobbs, Mississippi has made two arguments. One, that the Supreme Court should overturn Roe versus Wade outright, or in the alternative, two, the court should uphold prohibitions on abortion at 15 weeks on the assumption that this time frame suffices for women to access abortion care and does not amount to an undue burden, which is the legal standard for abortion regulations established in Planned Parenthood versus Casey, the 1992 case that Rose mentioned, that is, for the moment, the governing law. But Mississippi's assumption that a 15-week ban is not an undue burden is wrong. We have a good amount of empirical data about why people seek abortions after the first trimester and who would be most affected by a 15-week ban. And it's very clear that lowering the limit to 15 weeks will result in thousands more pregnant people unable to get the abortions they feel they need. And the people most harmed would disproportionately be low-income people and people of color. That is something we're already seeing on the ground in Texas. So in May 2021, Texas enacted SB 8, which effectively bans abortion at about 6 weeks of pregnancy before many people even realize that they are pregnant. Abortion providers in Texas have said that 85 to 90% of the procedures they previously performed were after the 6-week mark. What I think SB 8 has done, it has given the Supreme Court cover to covertly overrule Roe versus Wade without having to do so itself. Let's be clear, Roe doesn't exist in this country right now because the second largest state in the country has no access to abortion care. While SB 8 does present some tricky procedural hurdles, which I'll talk about in a moment, the Supreme Court could have clearly overcome those hurdles to enjoin this law in the emergency application that came before it already, but they failed to do so. So let me talk about SB 8 in a little more detail for people who aren't familiar. Now, typically when a state passes an abortion restriction, it passes a criminal or a regulatory law. That is a law that is enforced by a state official like an attorney general, a district attorney, a Department of Health official. The Supreme Court long ago, about a century ago, in a case called Ex parte Young, said that if a state passes a law that violates a person's constitutional rights, you don't have to wait to get prosecuted to raise your rights as a defense. So that is, you don't have to face this Hobson's choice of either not exercising your constitutional rights or taking a risk of being prosecuted. Instead, it's long been the case that individuals file a pre-enforcement lawsuit saying the federal court needs to declare that this law is unconstitutional and enjoin it. That is true in abortion cases. That is true in many other cases involving all kinds of constitutional rights. But because of procedural rules about standing to get into federal court and about sovereign immunity, you have to sue the person who will enforce the law to get the case heard in federal court. For the court to take jurisdiction and strike down a law that you believe is unconstitutional, you've got to sue the right defendant, the person who enforces that law against you. So the trick with SB 8 is its enforcement mechanism. So these are a few excerpts from the statute. I'll just highlight what this law does. It effectively bans abortion at 6 weeks of pregnancy because it authorizes any private citizen and forbids any state official from filing a lawsuit against, one, any person who performs an abortion in violation of the law, anyone who aids or abets such an abortion, including by paying for it through insurance or otherwise, like through abortion funds. And we don't know exactly what aids or abets means, it's very broad. And anyone who intends to engage in such conduct. The law has all kinds of other crazy provisions. It mandates that the court must award a private citizen plaintiff at least $10,000 in statutory damages, no harm need to be shown. It allows suit in any venue in the state of Texas, a huge state. It shifts payments of attorney's fees to abortion providers or advocates to the defendant, does all kinds of other wonky things I can talk about more in the Q&A. But the main problem is this private enforcement mechanism. As Justice Sotomayor wrote in her dissenting opinion in the emergency application, she said this Texas legislature has deputized the state citizens as bounty hunters, offering them cash prizes for civilly prosecuting their neighbors' medical procedures. That's what the law does because it prohibits state officials from enforcing SB 8 and instead relies on these citizen bounty hunters, which puts us in this procedural quagmire. Who can abortion rights advocates and providers sue to enjoin this law? There's no state official to sue technically or arguably. And so providers have stopped providing abortion care because it is far too risky for them to do so. SB 8 is effectively a self-enforcing tort statute. Just by being enacted and being on the books, it effectively freezes this constitutionally protected activity. So the legal chess game that we're playing right now is figuring out which court can we get into and who can we sue, and particularly who can be sued in federal court so we can get this law struck down. This is clearly unconstitutional, at least for now. So what we have is an array of lawsuits going forward trying to get this case struck down. So one is the federal court lawsuit by abortion providers and advocates. They sued a state judge and a court clerk, among other defendants, arguing that's how this law is going to be enforced. So those are the right defendants. That's the case. The Supreme Court has already denied emergency relief to prevent the Fifth Circuit from allowing SB 8 to go into effect, and may get heard in the Supreme Court again. After the Supreme Court refused to block the law, the Department of Justice then sued the state of Texas. That is United States versus Texas is the case. A federal district court hearing the US versus Texas case granted an injunction, but then the Fifth Circuit almost immediately imposed an administrative stay. And so SB 8 has gone back into effect. And then the third class of cases is a series of suits filed in state court. So one doctor, Dr. Braid, bravely came forward and said, yeah, I'm providing abortion, come sue me and let's get this law enjoined. And then that doctor also filed and he got sued by a couple of people in Texas state court. He also filed a lawsuit in another state court. So basically everybody's suing all over the place, trying to figure out how to get this thing struck down. So while we have this cacophony of litigation ongoing in many different courts, SB 8 is having a huge impact on the ground. The Supreme Court's refusal to intervene here means there's no access to abortion care in Texas right now, which has greatly exacerbated the health inequities that we have been seeing during the COVID pandemic, especially for those who cannot travel out of state. I also just want to note that SB 8 doesn't have any exceptions for pregnancies resulting from rape or incest, or for fetal anomalies. So I want to talk about impacts and who is most impacted, and put this in the framework of reproductive justice. Dorothy Roberts has described reproductive justice as a framework that includes not only a woman's right not to have a child, but also the right to have children and to raise them with dignity in safe, healthy, and supportive environments. And by sort of expanding the frame this way, it highlights the political context of intersecting race, gender, and class oppressions. So we're talking a lot about, Roe, whether it's going to stand or fall, but it's really important to recognize that the Roe versus Wade legal rule has never sufficiently protected access to abortion care for poor people and for people of color. Under the Roe regime, for example, the court also upheld the Hyde Amendment, which bans healthcare coverage for abortion for low-income individuals. So it's important to keep in mind who is going to be most impacted by these Texas and Mississippi cases, and what the spectrum of impacts of the Supreme Court's rulings are going to be. So I'm going to just present some empirical data on these points. We know from empirical data that bans on abortion will disproportionately impact the most vulnerable groups who already lack access to healthcare, as COVID has both exacerbated and exposed. So in particular, low-income people and pregnant people of color are disproportionately impacted. And again, low-income people have already lacked access to abortion care even while Roe was alive. And of course, now reproductive health disparities are exponentially worse in Texas. We already have in the United States a maternal mortality crisis, and empirical data shows that the maternal mortality crisis is borne disproportionately by Black women. And of course, that's only going to get worse as the court further allows state restrictions on abortion access, since abortion and maternal mortality are related, as studies have shown. So even if we are talking about maybe, I don't know if you call this a best case scenario, but maybe the best case scenario is they strike down the Texas law, but it seems likely that at a minimum, the court is going to cut back abortion rights to 15 weeks in the Dobbs case. That's going to have a huge impact, even if the court does not outright overturn Roe. So we have a lot of good data on the impacts of abortion restrictions from this Turnaway study in particular. It was a nationwide study that followed people who were seeking abortion care either just under or just over the time limits of 30 abortion facilities across the country. So some women in this study were able to get an abortion just in time, and others were turned away and later gave birth. There are about 70,000 people in the US per year who receive abortions after the first trimester. The Turnaway study found various reasons for this. One reason, more than a third of women seeking a second trimester abortion didn't realize they were pregnant until the second trimester. Some women have few symptoms of pregnancy. Young women especially would not recognize that they were pregnant. So for people who need second trimester abortions, especially people who are late in discovering their pregnancy, already a third of those people travel more than 100 miles and half visit more than one facility to find someone who can provide abortion care. So already over 4,000 women a year are unable to get a wanted abortion because they are too far along in pregnancy. If the Supreme Court in Dobbs decides to reverse the viability rule and lower the limit to 15 weeks, even more women will be unable to get the abortions they feel they need. That's one possibility of what the court will do. Another possibility is the court will outright overturn Roe and not only uphold the Mississippi ban, but also the Texas ban. What will happen then is people living in over 20 different states will then live in states that ban or severely restrict access to abortion. They'll have to travel over many state borders to obtain abortion care, or in many cases, carry the unwanted pregnancy to term. And again, remember, we already know about 75% of people who have abortions are low income, and more than half are people of color. So these abortion bans, whatever form they end up taking, are going to disproportionately harm poor people and people of color. And the Turnaway study also tells us a lot about what will happen, what the harms will be to women who are denied wanted abortion care. Oops, sorry, my slides just jumped forward here. Okay, I think this is the right slide, sorry. So women who were denied an abortion, data from the Turnaway study told us those people experience long-lasting physical health harm from carrying an unwanted pregnancy to term. 2 women in this study who were denied abortion care died following childbirth. Women who had to carry the unwanted pregnancy to term also had long-lasting economic insecurity. And the Turnaway study also found that these people who were denied wanted abortions were less likely than those who received them to achieve other aspirational plans, including providing for their existing children. And the majority of women in the US seeking abortion care already have children, and affected their ability to have children later under better circumstances. So I will wrap up here just noting this line from Planned Parenthood versus Casey, that the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. That is an ability that the court is poised to take away. And we know that the physical health and the economic security, especially of marginalized groups of women and pregnant people, is what is at stake. Thank you so much.
Great, thank you, Maya. And just so folks know, I am collecting your questions that are coming in via the Q&A. I think it actually will work better. I'll hold those to the end, but please keep them coming. Thank you so much. And as Dean Filler mentioned at the outset, one of the hallmarks of these law review symposia is that they bring into conversation both researchers and academics and also practitioners. And so after that fantastic sort of high-level review from Maya Manian, we turn to one of the providers who's on the front line of these legal and medical battles. So over the last 20 years, Jennifer Groves has worked with just about every organization related to sexual and reproductive health in Philadelphia and South Jersey. She's currently the Vice President of Clinical Operations for the Women's Centers, which runs clinics providing abortion services in Pennsylvania, Georgia, New Jersey, and Connecticut. Jen, thank you so much for joining us today after what I know has been an incredibly, incredibly difficult 18 months.
Thank you, Rose. And thank you for inviting me to speak today. My pronouns are she, her. So the symposium is a law review, but I am an abortion clinic worker, not a lawyer. So I'm going to talk about what abortion looks like on the ground in Philadelphia in these times. So Philadelphia Women's Center has been serving the people of Philadelphia since 1972. We are a privately owned independent abortion clinic. So for tax purposes, that means that we are not eligible for mainstream grants. And we also don't receive any government dollars, so including Title X in that. And that's different from hospitals and Planned Parenthoods in the area. It's important to note that, especially in these times of COVID. So independent abortion providers are basically the mom and pop shops of abortion care throughout the country. We don't really have a national organization that standardizes us, supports us in the creation of policies and procedures, legal support, lobbying, things of that nature. Philadelphia Women's Center sees people for medication abortions, local surgical abortions for both first and second trimester patients. We see people through 23.6 weeks gestation. And just to note that Pennsylvania's limit is 24 weeks gestation. So we're a day under that. It's also important to note that it's rare to find another provider in the state, whether they're a Planned Parenthood or a hospital, that sees patients through that gestation. So as a result of this, we see people not only from across the state, but up and down the entire East Coast. As Christine detailed earlier, even before the pandemic, it was pretty difficult to be a pregnant person in search of an abortion in Pennsylvania, especially if you're poor. So I ask you to consider layering in the pandemic with these pre-existing regs. So Medicaid covers the cost of an abortion only in the case of rape, incest, or life threat, thanks to the Hyde Amendment. Parental approval is required barring judicial bypass, even for teens that are already mothers. And there's also a 24-hour mandatory abortion counseling required that details mind-numbing things that the patients have already considered, like the fact that they can go after the man involved with the pregnancy for child support, and that they can apply for welfare. Like, people already know this. All of these barriers lengthen the amount of time and increase the number of hoops that people have to jump through to get care that is so time sensitive. Increased gestation equates to increased costs. It risks a person's ability to fall below the gestational limit imposed by Pennsylvania. It increases the physical risk and lengthens the recovery time following the abortion. So Philadelphia Women's Center sees about 6,000 patients a year for their abortion, but I need you to know that many more people walk through our doors that cannot be seen. Some of these people aren't even pregnant. Some have ectopic pregnancies. Some people aren't sure about whether or not they want to have the abortion today. And many of our patients are too medically complex and deemed unsafe to be seen in an outpatient setting. All of these things are traumatizing to a patient, except for not being pregnant, and requires a higher level of care. So the vast majority of the patients that we see are already parents. Many of them have already had an abortion previously. Some of them have had several. The population that we serve at Philadelphia Women's Center is primarily living at or below the poverty level. 65% of our patients have medical assistance, but as I stated above, it only covers the cost of an abortion in very limited cases. So as a result, our service becomes a cash-based service for a cash-poor population. The cost of a first trimester abortion has remained fairly steady over the past 40 years. Because in working with funds and in working with clinics, I can tell you that $5 really does make the difference as to whether or not a person can access an abortion that they need. What other surgery or service can you talk about in this country that has remained fairly steady in the cost to patients over a 40-year period? So despite our commitment to keeping abortion accessible cost-wise, other things don't keep in step with that. So we still have to buy supplies and equipment at 2021 rates. We have to offer our staff a living wage that is competitive in a really dense medical market like Philadelphia. We have to purchase life insurance and medical insurance for our staff. We have to pay physicians, rent. You get the idea. So whenever you hear about abortion providers getting rich off of people's misery, I need you to think about this. So it's always been hard to get an abortion in Pennsylvania. And as the years go by, it gets harder to provide abortion here as well. But in the early 2000s, things got even harder. A fringe provider in West Philadelphia was found to be operating a pill mill, in addition to a beyond subpar unsanitary abortion clinic that operated without unlicensed staff or moral medical standards. This physician's decisions hurt many desperate people and resulted in at least one death. It also changed abortion provision for every provider in the state. Following this, State Department of Health was under fire and enacted regulations across all of Pennsylvania that didn't increase the safety of an already safe procedure. Instead, the regulations crippled many clinics to the point of closure. So Philadelphia Women's Center had to make many difficult decisions in order to keep the doors open for the people that need us. These included installing an HVAC system and other expensive physical structural changes to the building that we didn't own, we were renting. Utilizing licensed staff in areas that were previously not needed and more. So we did all of this while in the crosshairs of the anti-abortion crowd. So they get us politically, they get our patients by making access so hard, they hit us with empty pockets, and they still find the time to stand outside the clinic and berate our staff and patients for daring to access a legal, safe abortion. Nearly every day, these oftentimes paid bad actors spew vitriol and threats at staff and patients in an attempt to curb a pregnant person's ability to access abortion. So now let's fast forward to the start of COVID. The vast majority of my staff are parents. Many of them are single parents of young children. As the world shut down, including schools and daycares, the need for abortion did not diminish by any means. So the Women's Center has always taken the position that while abortion is an elective surgery, there's very little that's elective about it. We are essential. When you think back to when the pandemic began, we all thought that we were looking at 6 weeks to 2 months. And even if that were true, and God, imagine if that were true, it would have made abortion unreachable for so many people. 6 to 8 weeks bumping up against the 24-week gestational cutoff would have hurt so many people. We did not close our doors. We deemed ourselves an essential service, whether or not the governor was going to do it. Thank goodness he did, but we deemed ourselves essential. I'm really proud of that. But the world was and is still on fire. So many of our moms that work at the center had no place to put their children so that they could come to work every day. And even if they could find someone, the cost of childcare made working not make sense for their families. Couple this with the fear and spread of COVID. Many of our staff have autoimmune issues and pre-existing health conditions that made COVID extra scary. The pregnant people needing to no longer be pregnant didn't lessen. Our appointment schedules remained full. Like many healthcare agencies, we shifted to quickly try and make things be safer. Hand washing, gloving, and masking in areas where we never gloved or masked before, spacing our schedules to lessen the number of folks in the center, plexiglass barriers, eliminating the ability to allow escorts and support people in this space, scrounging for PPE for staff. So I need for you to think about, if it was hard for mega hospital sites to access these supplies, think about what it looked like for an independent abortion provider. It was hard and scary, and to be honest, many of us left because we had to, and many never came back. In the early months of COVID, I think the patients were so surprised and thankful that we were open. Compliance with CDC guidelines was a little easier. People will and do jump through hoops to get their abortion. COVID was no different. But as you know, COVID quickly became polarizing in our country. Here we are, a year and a half later, and COVID fatigue is a very real thing for healthcare workers. And I get it, but for abortion workers, guys, for abortion workers, it's harder. All of the barriers to providing and accessing abortion are still here, just add COVID. The labor shortage is making it even harder for us too. Hospitals are offering sign-on bonuses and shift bonuses for staff and still not getting workers in the door. We can't compete with that. The shoulders of everyone that is hung on by the skin of their teeth just gets heavier and heavier in these abortion clinics. We know we are in the right fight and we're determined, but we're so very tired and beaten down. I've worked in this field for a really long time. Expanded access to abortion is a dream, and COVID has increased telemedicine and people's ability to access medication abortion with more ease, supposedly. because to be honest, I didn't grow up with expendable cash or a credit card. And I still question who can access these medication abortion services with the financial ease and confidentiality that I know my patients require. Still, expanded access is the dream, but I want to tell you that I didn't dedicate my life's work for privileged people that will get their abortion because they can figure out how to navigate any system or law. I'm here for the purposely disenfranchised, the drug addicted, the mentally ill, the people on the cusp of the cutoff limit for the state, the second trimester abortion patients that need us. So in conclusion, I want to ask this powerful group of allies, where is the expanded ease of access in this mess for those people, and what are you willing to do to help? Thank you.
Thank you so much, Jen. Really appreciate not just your words, but all of the actions of you and your staff across these states over the last 18 months. And so I am delighted to welcome Rachel Rebekah to join us next. She is the interim dean at Temple University Beasley School of Law and is herself the James E. Beasley Professor of Law. Today, Dean Rebekah will discuss the implications of legal and technological changes to remote abortion access during COVID. Dean Rebekah, take it away.
Thank you, Rose, and thank you, Liz Kakura. Thank you, Drexel Law Review, and thank you, Dean Filler. This is a wonderful gathering, and I'm delighted to be a part of it. And I'm actually going to pick up right where Jen left off, changing gears a little bit to talk about the emergence of telehealth for abortion, which I think offers at least one reason to be optimistic about abortion access. But I want to spend some time today to talk about the significant limitations of telehealth for abortion. So as Maya described, the legal terrain for abortion is changing. We have the Dobbs oral arguments in December. We have SB 8 showing a willingness by Texas, the court, the Fifth Circuit, to abandon constitutional protection for pre-viability abortion through procedural maneuvering. But I want to spend some time today to talk about some practical access issues for abortion that are changing too, and that's the growth of virtual clinics, which offer medication abortion through telehealth, the 2-drug regimen that ends pregnancy before 10 weeks, which follows a court decision that temporarily enjoined one of the FDA's restrictions on the first drug in a medication abortion, mifepristone. So I'm just going to give you a little bit of background about that case, about the FDA's regulations, just for context, and then talk a little bit about what's happening now. So the FDA applies a drug safety program to mifepristone, a risk evaluation and mitigation strategy, or REMS. And the FDA issues a REMS for drugs it deems potentially risky and in need of monitoring. In addition to a REMS, the FDA can issue an elements to assure safe use, which can circumscribe distribution. So said a different way, the FDA requires patients collect mifepristone at a healthcare facility, so a hospital, a clinic, a medical office. And the effect of the in-person requirement has been to prohibit retail pharmacies and mail order prescription services from distributing mifepristone. The FDA, however, does not mandate that the provider be physically present when the drug regimen is collected or taken by the patient. So of the 20,000 drugs regulated by the FDA, and with the 17 that have the same strict restrictions, mifepristone is the only one that patients must retrieve at a healthcare facility, but may take without physician or provider supervision. So, and in fact, the FDA permits mailing to patients' home the exact same drug compound in higher doses and larger quantities for the treatment of other conditions. So shortly after the COVID-19 pandemic began, the American College of Obstetricians and Gynecologists brought suit with 4 other parties to enjoin this in-person dispensation requirement. And ACOG argued that applying the requirement contradicts substantial evidence of the drug's safety and is ineffectual in protecting patients. In July 2020, a US district court agreed and issued a nationwide injunction of the in-person collection requirement for the duration of the pandemic, the court held that the FDA requirement imposed an undue burden of the kind that Maya described, because requiring travel to a hospital, clinic, or medical office to pick up a drug that you can take at home offers no medical benefit. So retrieving mifepristone at a healthcare facility does not reduce the likelihood of a complication, which is very rare. Typically, a provider will not be present when the abortion begins, and a patient will not be at a healthcare facility. And any possible health benefit to a patient is outweighed, the court said, by the burdens imposed, such as increased risk of exposure to COVID-19, the cost of travel, delay, other logistical hurdles. More notably, the opinion illustrates how abortion restrictions interact with health stressors that perpetuate inequalities exacerbated by the pandemic. The FDA's policy falls heaviest on the predominant populations of abortion seekers who live just above or below the federal poverty level and are people of color. So making the connection between inaccessible abortion, income, and race, the district court and the experts at site built off of studies such as the Turnaway Study, which Maya mentioned. So just to highlight that here, the study's authors concluded that people who were denied abortion versus those who had abortions experienced worse health and higher poverty rates over the following 5 years. The Supreme Court was not convinced by the district court's reasoning, by ACOG's argument, or by any of this evidence. It stayed the district court's injunction in January 2021. Justice Sotomayor wrote a powerful dissent calling the court's reinstatement of the FDA rule cruel. But last April, the FDA exercised its enforcement discretion and has not been requiring in-person dispensation during the pandemic. In May, the FDA announced it would review the elements of the REMS for mifepristone by the end of the year, and that review will rely on information provided by the sponsors of the drug in a new drug application, as well as the numerous studies that show that mifepristone is very safe, as is telehealth for medication abortion. So after the FDA's decision to lift the in-person collection requirement, virtual clinics have expanded. And I want to describe one for you that's Abortion on Demand, the first large-scale telehealth abortion service run by a US-based provider. And it launched in April 2021. So an automated asynchronous intake is followed by an online appointment with a physician and an informed consent process using a pre-recorded video. The patient does a virtual chat, and the entire process from counseling to termination completion takes between 2 to 5 days and costs about $300 less than clinic-based procedures. Abortion on Demand prescribes medication abortion up to 8 weeks rather than 10 weeks, and only for people 18 and older in order to avoid being trapped by parental involvement restrictions. It now operates in 21 states, and along with Genuity, which was a teleabortion service that based on an investigation that was happening before the pandemic, and Aid Access operates in 21 states and is hoping to expand to 27 by the end of the year. In addition, Plan C, a nonprofit that works with physicians and providers certified to prescribe medication abortion and willing to mail the regimen to patients, operates in 6 states. So just as Jen mentioned, there are significant challenges to telehealth expansion, and there are reasons to be concerned about the barriers that exist to access to teleabortion. For one, telehealth depends on various forms of privilege. Utilizing smartphones, having a stable internet connection, or having an uncomplicated pregnancy, which, because of the deep health disparities in the United States, is more likely the case for wealthier and white people. For another, about half the states do not permit teleabortion. This corresponds with the states that will ban or substantially limit abortion services, the map that Maya showed, if Casey is overturned or substantially revised. Hostile states have and will try to further restrict abortion inside and outside the state. There are any number of examples that could come to mind. State laws that attempt to restrict travel or limit out-of-state providers from prescribing medication abortion. And states like Texas are already legislating to restrict medication abortion generally. SB 4, which is going to take effect December 2nd, bans medication abortion after 7 weeks. Finally, even with remote care, the need for clinical spaces for abortion past 10 or 11 weeks, or when a patient is not a candidate for telehealth, will not disappear. And I note that recognizing this, Abortion on Demand donates a portion of its proceeds to the abortion care networks Keep Our Clinics Fund. All that said, teleabortion, because of its design and based on how it's implemented, could be a vehicle for delivering care across state lines. Federal law, like the proposed Women's Health Protection Act, which the House passed recently, could attempt to keep states from trying to limit travel or to enact rules that freeze remote care or punish self-managed care. So what will remain in the midst of legal uncertainty is a problem of resources, just as Jen discussed. And here we can talk about how movements rooted in health justice and reproductive justice, how advocates, researchers, and lawyers could work together to ensure that people have access to those resources, to enable low-income people in hostile states to access abortion care. How can movements empower people and disseminate information about abortion resources? So those are questions that I can't answer in my limited time, but I'm going to leave them for discussion. And thank you again for inviting me here today.
Thanks so much, Rachel. Our final speaker today is Farah Diaz-Tello, who is Senior Counsel and Legal Director for If, When, How. Her work focuses on ensuring self-determination for pregnant people, and her comments for us this morning will examine how COVID has changed both perceptions of and access to self-managed abortion. Farah, thank you so much.
Sure thing. Happy to be with you. Let me go ahead and share my slides with you. All right, so as you just heard, my name is Farah Diaz-Tello, and I am a Senior Counsel and Legal Director with If, When, How, Lawyering for Reproductive Justice. And we're going to talk today about self-managed abortion and how the landscape has been affected by COVID-19. But I wanted to start off by giving a little bit of an introduction to my organization and the work that we do. So you may be familiar with us as an on-campus entity, and we work to organize the legal profession from the moment they set foot on law school campus to the time they're appointed to the Supreme Court. And in addition to that, we do impactful litigation and policy advocacy and provide legal advice, all to ensure that everyone has the rights and resources that they need to determine if, when, and how to carry a pregnancy to term and create a family. So my work focuses on ensuring that people have access to care across the spectrum of their reproductive experiences, including abortion, pregnancy loss, and birthing, and that they are able to have care that affirms their human rights and that exists without coercion or punishment for the decisions they make. And one of our strategic initiatives, and the one that brings me here today in particular, is our work to halt the criminalization of people who end their own pregnancies. But before we get further into that, I wanted to start with a little bit of a level set on the terminology we'll use here, because it's a bit of a pivot from the presentation that you just heard. So I want to make sure we're on the same page. When I am talking about self-managed abortion, I mean any means that a person might use that's self-sourced in order to end a pregnancy. And they might do that alone, or they might do that with the support of another individual who is outside of the formal medical system. So this is distinct from telemedicine or telehealth abortion, which involves a clinician who prescribes the medications. And there's some nuances there that we can get into in a bit, but for now, this is our sort of working definition. And historically, self-managed abortion, well, it has existed for as long as people have been getting pregnant, right? So self-managed abortion has included the ingestion of substances like foods, herbal remedies, and other plant-based medicines. It can include certain types of massages or other treatments. It can also include inserting objects into the cervix or physical trauma to the abdomen. So some means of self-managed abortion are safer and more effective, and some are less safe and less effective. The importance is that we want to ensure that regardless of the method that a person uses to self-manage their abortion, that they aren't subject to criminal penalties for doing so. The good news is that advancements in reproductive health technologies have made self-managed abortion medically safer than it has ever been in human history. So self-managed abortion looks like many of the other ways that people meet their health needs outside of the formal medical system, using the internet, using offshore pharmacies, when healthcare is inaccessible for a variety of reasons. And some groups that are facilitating access to abortion medications use creative means to drive policy change and to highlight the hypocrisy of the gatekeeping that lawmakers engage in with respect to these reproductive health technologies. So you can see there at the bottom, there's an abortion drone that was flown from Germany, where abortion is legal, to Poland, where it is prohibited, just to show the hypocrisy of abortion policies that restrict access to these safe and life-saving medications. But I want to be clear that our position that nobody should be punished for ending a pregnancy isn't predicated on the use of abortion pills. And in fact, in some of the histories of resistance to the medicalization of abortion, like the Jane Collective and the Feminist Women's Health Center self-help groups, many of them involved safe abortions using suction, including using devices that women invented themselves from household equipment, as you can see in the image, as well as curettage. So when we say nobody should go to jail, we mean nobody ever, regardless of how they ended their pregnancy. So it's difficult to accurately count abortions that take place outside of the formal medical system for reasons that are self-evident. But research suggests that it's actually quite common. So a study that was published in 2020 estimated that 7% of US women will attempt a self-managed abortion. And between 2018 and 2020, one online service received more than 50,000 requests from all 50 states for a medication to self-manage abortion. And the reasons that people have for wanting to self-manage are, probably come as little surprise, right? Some people feel pushed out of the health system by factors like accessibility of clinics, by waiting periods, by harassing protesters, lack of culturally responsive or gender affirming care, right? There are lots of reasons that the clinic space is inaccessible for some people. And others feel pulled towards self-managed care by a desire for a more private experience, or to be able to be accompanied by loved ones, or to be able to incorporate cultural or traditional practices. So what's important here is that whatever an individual's reason is, or whatever their preference is, people should have access to care that meets their needs and affirms their dignity, whether that is in a clinic with a healthcare provider or at home with a trusted friend. Research bears out the complexity of people's decision-making around self-managed abortion. So research conducted by Abigail Aiken at the University of Texas's Project Sana asked people in the US who sought abortion pills online why they were seeking access to self-managed care. And their research showed that the majority of people had a mix of reasons, some push factors and some pull factors, with cost being the most frequently cited reason. So those costs that are inflated by the state imposed regulations on abortion care providers. And then that was followed by other reasons like the privacy of the home environment or the need to keep the pregnancy or the abortion a secret. And of course, relevant to our conversation today, the COVID-19 pandemic presented its own set of needs. So the need for stay-at-home healthcare, including abortion, only increased during the pandemic, and demand to one online source for abortion medications increased by 27% in the month after stay-at-home orders began. And this could be attributable to a number of factors, including lockdowns, lack of access to healthcare just generally, the economic downturn and loss of income generated by the pandemic, right? And one interesting thing to note here, if you can see this little excerpt from the data, is that the increase wasn't borne equally across states. So Texas, which initially and opportunistically deemed abortion care to be non-essential in its shutdowns, saw a 93% increase over the baseline of requests. Yes, okay, you can see it there. And but the increase didn't just occur in least access states like Texas. Other states hit hard by early waves of the pandemic, like New York, also saw a jump in requests for self-managed abortion through this service. So with the pandemic, we see a greater likelihood that people might face an unwanted pregnancy because they're unable to access their birth control and just unable to control their lives in a variety of different ways. And they also might not be able to access care in a clinic-based setting. So commonsensically, this leads to a greater demand for self-managed options. What's somewhat less straightforward is the legal backdrop across against which this occurs. So the good news is that the trend, both historically and in the modern day, is that self-managed abortion is not codified as a crime. So when we talk about illegal abortion, what we really mean is something that one person does to another person who is pregnant, right? Not something that a person who is pregnant does to their own body. That being said, people have been criminalized and even spent significant time in prison for having allegedly self-managed an abortion. So we had previously documented at least 24 cases in which an individual was criminally charged for ending a pregnancy or helping a loved one do so from the year 2000 to the present day. But we're currently in the data collection phase of a study that seeks to examine the true extent of criminalization for people who self-manage their abortions. And what we've found is that there are many dozens more cases than what we initially believed. And these cases have used an amalgamation of legal theories. Here are the states with laws that criminally ban self-managed abortions still on the books. And the good news is you can see there has been some change. Even just this past summer, Delaware and Arizona both repealed their laws imposing criminal penalties on self-managed abortion. And it may come as a surprise to folks, given the sort of presence of the threat of criminalization, how few states there actually are on the books. And the thing is, that's been the case historically. So you can see this language here from Roe versus Wade, that even the Texas criminal abortion statute that was at issue in that case didn't criminalize the pregnant individual or a person who submitted to an unlawful abortion or otherwise ended their pregnancy. What was much more common were criminal abortion laws, so the laws that made it a crime to provide abortion for another person without the legal authority to do so. New York, we recently repealed ours in 2019, New Mexico as well. We've seen these states that you see here highlighted in blue are the ones who have changed their laws really within the last 4 years. So we see concerted effort on the part of states to future-proof their codes, their abortion codes. And the unfortunate thing is that in some of these states, we've seen prosecutors use these laws against individuals for self-managing abortion on essentially a legal theory that the person is their own unlawful provider, right? So they have not complied with the abortion laws, and they therefore should be criminally charged the same as somebody who is providing abortions outside of what the code permits. And then finally, we have fetal harm laws. This is a much newer, much more nefarious trend. These are laws that are passed usually in the name of protecting pregnant people from harm by others. And they do so by making it a crime to harm a fetus. So you may know them as unborn victims of violence laws, feticide laws. And the vast majority of states have one of these. At this point, 38 states have a feticide law. And the ones that you see highlighted in blue here are the ones that don't have a provision that explicitly accepts the pregnant person from criminal prosecution. There has been some positive developments here. In Indiana, they reformed their law to include a provision that prohibits the charge from being used against a person with respect to their own pregnancy. And Rhode Island recently repealed their feticide law out of concern that it would be wrongly used against pregnant people. But all these maps essentially are meaningless because here's the map of states where criminal prosecutions or criminal investigations at least have taken place, right? And you can see that there's virtually no correlation between the laws that I just laid out for you and where criminal investigations have actually transpired. Because frankly, the words often don't mean anything, right? Once a prosecutor has decided that they want to punish somebody for having an abortion, they're going to find a way to do so. And that could be through any variety of the laws that I just mentioned, or any of another grab bag of concealment of a birth, these like 19th century laws to punish out of wedlock births, or concealment of a body, improper disposal of human remains, right? It's just sort of up to the prosecutorial imagination to decide how they're going to punish people for abortions. It's not all bad news. So we've seen some states or some jurisdictions actually, because DC is one of them, that have actually passed laws that include anti-criminalization language. They explicitly say that people won't be criminalized for seeking abortions, for having miscarriages, and for other adverse pregnancy outcomes. And we have to see more of that in the future. So I'm guessing that many of you might have questions about SB8. You've already gotten a bit of a primer to SB8 from Professor Mannion's remarks. We call it the Sue Your Neighbor law, as well as SB4, which further restricts abortion with pills. And you might be wondering, whether these increase criminalization of people who self-manage their abortions. And the answer is they don't and they do. So SB8 imposes civil penalties on anyone who performs abortions or aids or abets an abortion at the time embryonic cardiac pole activity is detectable. So that's about 6 weeks gestation. It doesn't carry criminal penalties. And it explicitly does not impose liability on an individual who ends their pregnancy after 6 weeks. SB4 expands current abortion restrictions to impose criminal penalties on anyone who provides abortion pills to anyone who is more than 7 weeks pregnant. So you can see it's sort of moot if you take into consideration SB8. And notably, this isn't just restricted to healthcare providers. So it could apply to anybody who ships medications, who gives medication to a friend, or who in any other way helps a person obtain abortion pills. So neither of these directly impose criminal or civil penalties, but they do create conditions in which people can be harassed, intimidated, and even criminalized. So in addition to just simply banning abortion care, they create a chilling effect where people are cut off from the systems of care like abortion funds and practical support networks, and even just their family members who make it possible for people to access abortions. They also increase the criminalization and other legal punishment of activists who might be sharing critical information on where to access safe medications and when to seek assistance in the event of a complication. So by creating causes of action under criminal and civil laws, these statutes also open the door for hostile actors to abuse the legal system and seek information about people who've self-managed their abortions. So anybody who's ever filtered through discovery knows the staggering amount of information that can be dredged up in the course of litigation. And even if the target of an investigation is somebody who helped a person end a pregnancy, the one who's most visible to the legal system, thus most accessible, is the individual who ended their own pregnancy. So they're likely to be caught in this sort of informational dragnet. Also, these laws falsely exceptionalize abortion as uniquely dangerous and somehow nefarious, which makes it more likely that people are going to be ensnared in criminalization. Because abortion stigma, and not abortion pills, is what poses the greatest risk to health and safety in the case of self-managed abortion, because it deters people from seeking medical care in the event that they need it. Because as it turns out, the most important factor and whether or not a person is going to be criminalized isn't what the law says, but it's whether a person who presents with a miscarriage or an abortion is met with hostility and stigma, because the stigma itself is what leads to criminalization. Because the truth really is that criminalization isn't about what the law says, but rather about how society categorizes you. So we're now finally reckoning with the fact that what the law says is just one factor affecting criminalization, and that a person's race, their socioeconomic status, their contact with other state systems are going to determine whether or not they're actually criminalized. So just to give a very sort of broad sense of what we think that the future holds, certainly we see an increased attention to self-managed abortion, and that's in the advocacy world, but also on the part of abortion opponents. And we're already seeing sort of the use of rhetoric like toilet bowl abortions and chemical abortions on it to try to like cast aspersion on abortion with pills to make it seem as unsafe as possible to be able to regulate that. Because if you think about what are the sorts of interests that the state can assert when it regulates abortion, the health of the pregnant person is one of those, right? And so if we can say that self-managed abortion is unsafe, then we can start to control it under the law. Some of these things, they were in a crystal ball. They've actually started to come to pass. Criminal sanctions on people who assist others with seeking information, seeking medications, state level bans on abortion pills. I think that previously we had been worried about federal bans. Lawmakers had reached out to the FDA, encouraging them to crack down on people who were importing abortifacient medications. And I think that now we're going to see that coming more from the state level. And this last piece, rhetorical shifts that play on movement rifts. I am always surprised by how savvy the opposition is in terms of being able to identify what the weak points in our analysis are. And so, we've certainly seen people who help others access pills being deemed traffickers, right? Saying like the only reason that somebody would have for wanting to order and distribute lots of abortion pills is if they are trafficking young people, right? Like that. And so because of our sort of not fully developed analysis as a movement around how we deal with sex work, how we deal with drug policy, right? Treating people who assist others in obtaining pills as drug pushers, or like people who are essentially like engaged in drug trafficking or human trafficking. So things to watch out for on the horizon. But ultimately, I have to say that I'm an optimist, and I see a lot of promise in this moment, right? Because we've seen an unexpected opportunity to innovate and really rethink how people access care. Because of the pandemic, more people have access to pills by mail than they ever have before. People are talking more about self-managed abortion as an option. And we see other innovations like advanced provision of abortion medication really sort of taking hold in the medical community. So advanced provision being providing abortion pills to people before they become pregnant so that they can have them on hand when they do become pregnant. And all of this gets us closer to a day in which people have meaningful access to a range of options. I'm going to close it out by highlighting some of the work that we're doing. Obviously, we're doing legal and policy work using litigation to support people to defend them when they are ensnared in criminalization, policy advocacy to change the law to ensure that they don't find themselves in that situation in the first place. But I wanted to highlight two of our direct service strategies, and I hope that y'all will screen cap these. First is the Repro Legal Helpline, which provides legal information, brief services, and referrals to people who want more information about their rights and potential risks related to self-managed abortion, and to young people needing abortions as well. And helping people understand the law and its possible consequences for them is really critical to helping them make informed decisions about self-managed abortion. So we do this through a variety of secure and encrypted means. We offer our resources in Spanish and in Chinese and have translation services available. And then our most recent program that we've added this summer, we launched our Repro Legal Defense Fund, which helps people who are caught in criminalization to help blunt some of the many onerous costs that are associated with being subject to a criminal investigation. So this can include bail to secure their swift release, criminal defense, family defense, and immigration attorneys, the fees for that. Expert fees, and the many other costs that are associated with getting people free if they're criminalized for having an abortion. So we hope that nobody needs these services, but we're ready to assist if they do. So with that, I thank you very much for your time. It's been a pleasure to talk to you, and thanks.
Great. Thank you so much, Farah. So as you will note, if you were looking at your clocks, which I'm sure we all are, we are almost out of time. And I will also just note that due to staffing shortages, Jen Loesch from the Women's Centers did have to leave to go back to work. So let me just ask, there were just a ton of really wonderful questions in the Q&A, and I apologize that we're not going to really have time to get to those. But maybe we could just take a minute and maybe some of the panelists might reflect very briefly on whether and how COVID might challenge us to think differently about ensuring access, both formal rights to abortion and also meaningful access for so many people. Is there anything that we can take out of the pandemic that you see as sort of opportunities to question, reevaluate, and maybe move forward? And I will throw that open to anyone. But like with class, I will call on you. Maya, do you want to take a stab at this?
Sure. I mean, I think what both Rachel and Farah just explained so beautifully, that COVID has normalized telehealth. And that to me, and self-managed abortion, and that to me is a silver lining that's become normalized. And again, it's not a silver bullet. It doesn't solve underlying problems about resources and access and potential criminalization, but it's a huge way to expand access, even in a world where, we don't have constitutional rights to access abortion care. The other thing I positive, I hope, that can come out of COVID is just greater awareness of health disparities and health inequities, and that is a much bigger problem that abortion is one part of, and that we need to look at the social determinants of health. And I hope then what we do is really that the reproductive justice framework takes off more as a political movement. I think that's going to have much more purchase than this old language of choice. I mean, it is an old language, and I don't think it captures what we need anymore. So I hope we really pick up on linking abortion with all these related issues, access to contraception, maternal mortality, prenatal care, welfare, and support for people having babies that they want to have, and that we link all that together and connect abortion rights with a broader health justice, reproductive justice, and social justice movements.
Thank you so much. Do any of the other panelists want to weigh in very quickly in our last minute or so? Okay, Christine, great, thank you.
Yeah, and I'll just add, I think also to what COVID-19 revealed was that access to abortion and other reproductive health services varies from where you live, and that it is critical to secure rights and protections on the state level and local level. And so that I just want to uplift WLP's litigation that we're in right now. We just filed our merits brief before the Pennsylvania Supreme Court in our challenge to our state's Medicaid coverage ban for abortion, representing many of the providers here in Pennsylvania, and also co-counseling with Drexel Law Professor David Cohen. So I encourage folks to check out our page on that.
Great. Thank you so much to all of our panelists this morning. I think you did such a wonderful job of illustrating both so many of the promises and the benefits that we might have learned over the last 18 months, as well as really bringing our attention to the continuing inequalities that exist. So thank you all so much. For our participants, we now have a 5-minute break, and look forward to seeing you during the rest of the day. Again, thank you so much.